Thank you, everybody, for coming tonight. I'd like to introduce and welcome Scott Herrick. He serves as counsel to the Police and Fire Commission. My name's Amelia, and most of you know that. We're on the community response team together. I'm a member of the community response team we formed in response to the death of Polly Heenan, who was shot and killed by a Madison police officer in front of mine inmate's home. The community came together and just sort of started looking at policy, training, and needs surrounding the Madison Police Department. Over the past few years, we've conducted several community meetings where we had people like Scott who are involved with the criminal justice system or the law enforcement system or groups that are connected to those systems on panels where the public is free to ask questions. And over time, we would also collect questions after the meetings and collect questions in advance. And these questions started piling up, and we noticed that we just never quite got through them during the community meetings. And that was okay, because there were people at the meetings that needed to be heard and needed to have their questions answered right away. And we wanted to respect that. Tonight is a different format. We're taking some of these questions that are 2 years old now, and they have to do with the functioning of the Police and Fire Commission, what the PFC is, how it functions, what its power is. And our goal tonight is to allow Scott to give that presentation in 3 sections. He's going to be answering our questions that we forwarded to him already in advance. And so after each section, we'll be able to ask clarifying questions. This is not an event where we will be getting to the bottom of our own personal experiences with the Police and Fire Commission. That is not something that Scott can do or is going to do tonight. If anyone has any concerns about their experience with the Madison Police Department or the Police and Fire Commission or any of the above, please talk to one of the members of the CRT. Can everybody raise their hand right now? And we'll talk, we'd love to have you come to our next meeting and talk about resources and possibilities concerning your concerns. But for tonight, Scott will only be able to answer legal questions about the commission and not about specific PFC decisions or members. Thank you, Scott. I think I covered it all. Is that right? Did I say everything I need to say, you guys?
Clarifying questions?
So three sections of questions. After each section, there'll be a few minutes for clarifying questions. Questions pertaining specifically to the topics that we are covering tonight. And so I'm just going to ask that we respect that. Scott was at our last large community meeting where he had a whole presentation prepared. We got to none of that because we opened it up to public questioning. And like I said, we really wanted people to have an opportunity to have their questions answered that time. So we've asked Scott to come back again, and despite the fact that he spent 3 hours without answering a single question that night, he has agreed to come back and actually answer the questions that we forwarded to him. And so we're grateful for that. So after each section, Scott can just say clarifying questions, and if you wouldn't mind just throwing your hand up, and Scott can call on you, and that should work out fine. I'll just time it, and I'll just let you know when the time's up, and we can move to the next section.
Okay.
Does that work? Okay, great. Thanks all, and please, food, drink, feed yourselves. Thank you.
Thank you, Amelia, and thank you for giving me a chance to try to address some of your questions. I didn't have a real presentation ready. I don't feel badly. I wasn't hurt that I didn't get to answer any questions last time. You had sent me some questions ahead of time, and I kind of looked them over and was ready to talk to you about that, and I'm happy to try and talk to you about it tonight. You know that I'm a lawyer. In order to prove that, I have to begin with some disclaimers or cautionary comments. Otherwise, you won't believe that I actually am a lawyer. You might doubt it, and there's at least one other lawyer in the room who would turn me in if I didn't say from the beginning that this is for informational purposes, with, if I'm lucky, educational purposes, not legal advice. I'm not giving anybody any legal advice, nor any other advice. Just trying to provide some information and what have you. That's a good general principle when lawyers are public speaking, and there's another specific reason, which is that, in fact, I have a client. You're not my client. My client is the Police and Fire Commission. So that's who I give advice to. If I start giving advice to other people, they shouldn't trust it, because my client can trust my advice. I might mention that the PFC is aware that I'm speaking with you. It's encouraged me to come out and talk with you for public information purposes. But as you can imagine, I'm not expressing any views of any commissioners or any policy positions of commissioners or pretty much of the PFC, although from here and there I may refer to something that the PFC likes or doesn't like, but by and large I'm just trying to provide information in that kind of platform way. You sent me a good bundle of questions, thanks to Amelia for sending me those, and I looked them over, and to me they fell into some groups, and I kind of grouped them just like Sesame Street. Some of these things belong together and some of these things are kind of, you know. The groups that seem to fall in place with those questions for me are questions that pertain to the existing complaint process or procedures. That just fell out as what I call my group one, just because of the way the numbers were. The second group that I came up with was questions relating to the commissioner's appointments and PFC administration generally. The third was questions pertaining to optional powers. All of those questions are questions that I'm content to try to address. And then there was a fourth group of several questions that I just didn't feel that I could undertake to address, mostly dealing with policy questions or with specific cases, or just questions that I prefer not to answer or try to answer in this kind of context. So I'm not going to talk about those. And Amelia didn't mention 4 groups, she mentioned 3, because we're going to talk about 3. And we're going to talk about the first group first, that is the complaint procedures. Then we're going to talk about the third group, because Amelia kind of prioritized that. In other words, we'll talk about the optional powers questions in our second round. And then thirdly, we'll talk about commissioner appointment and the kind of PFC administration. And I think the first group of questions pertains to the complaint process. And let me read the first one, because this first question has a word in it that is, in fact, I'm going to ask you to guess what my favorite word in this question is. And I'm not going to allow the lawyer in the room to make the guess, because I bet she would know what my favorite word is. Here's the question. What is the process for a person who wishes to file a complaint with the Police and Fire Commission against an officer, and what are the possible outcomes? Now, what do you suppose is my favorite word in that question? It's a wonderful question. Great way to start.
Process.
Process is my favorite word. You're right. This question allows me to talk about the PFC process. And we're talking about the complaint process. We're not talking about the hiring process or the promotion process, but the complaint process. First, a preliminary comment about words, phrases. We talk about complaint. I often use the word complaint. I just did a couple times. Strictly speaking, in talking about the PFC process, we sometimes should be careful to use the phrase statement of charges, because that's actually the statutory phrase. Tonight, by and large, I'm not going to be hyper careful to always say statement of charges, but sometimes we need to make the distinction between a complaint, which might be a gripe, a concern, a worry, and a statement of charges, which is a more formal item that begins the PFC process. It's the first step in the PFC process. So if I'm a little sloppy about you saying complaint sometimes and statement of charges sometimes, bear with me. I reserve the right to make that distinction when I have to along the way. There's a key factor in the PFC process, the complaint process. It's one of two things. tonight that I really want to use the board for. It's an adversarial process. What I mean by that is there are parties. One of the parties is the party who's unhappy, who's bringing the statement of charges, who's filing the complaint. In a lawsuit, we would call that person the plaintiff. In a criminal case, we might call that person the prosecutor. That's the person who's moving forward with the charges. Prosecutor, complainant. Complainant is the word to use in an administrative proceeding. The person with the complaint is the complainant. The other party in a lawsuit is the defendant. In an administrative thing like a PFC case, we call that person the respondent. So sometimes we use a delta for that, or a respondent. So we've got parties. That doesn't make it an adversarial system. What makes it an adversarial system is that the parties are in front of, or before, or in, or whatever prepositions you want to use, a tribunal. The PFC is the tribunal. So you've got the parties, but you've got the tribunal. This would be a court if we're talking about a lawsuit. And in fact, this PFC process is frequently referred to as quasi-judicial. Quasi, sort of. Judicial. Court. So it's sort of a court procedure. Depending on what we're trying to say about it at any given time, we emphasize one way or the other. If we want to say that it's not really a court, we say it's quasi-judicial. And if we want to talk about how it's like a court, we'll say it's quasi-judicial. So it kind of depends on where you put the emphasis on the syllable as to which it is. But in any case, this process, this adversarial process, is quasi-judicial, meaning that it's a hearing in which the parties present their case to the PFC. The PFC hears the case, conducts the hearing, hears the case, makes a decision. One of the a follow-up part of this question is what happens, what results? And what a PFC can do as the result of a hearing, if it finds that the complainant wins, if it sustains the charges, then a PFC can suspend, demote, or discharge an officer. Suspension meaning as a penalty. Basically dock somebody's pay. Demote, reduce in rank. Discharge, fire. That's all a PFC can do. There are two big things, or two big categories that are not on the board. The PFC does not investigate, does not prosecute the case. Look at the role of the PFC. It hears the case that is presented to it. That's its job. It is the court. It is quasi-judicial. And that's all it can do, those three things. There's no abstract, well, maybe there is, but I won't try to put an abstract philosophical reason on why there are only these three penalties on the PFC list, but that's the way the statute is written. Look what's missing. Reprimand, training, probation, reassignment of duty, any number of ordinary administrative personnel management tools are not on the list of what the PFC can do. The PFC can suspend, demote, discharge. In principle, it can do a combination of those things. For example, it could demote someone and suspend that person. But it can't do anything else besides those three things. And believe me, when I say can't, I mean can't, because there's clear and explicit case law in which efforts to try other things have been shot down, and it's been true and known for years that that's what a PFC can do only. So that's the PFC process. Contrast it, just a quick comment, and then I'll move on to your second question on this category. Contrast this with the departments, the police department, and for that matter, the fire departments, in what we sometimes call their internal complaint process, or their professional standards internal affairs process, PSIA, which is, in fact, an investigative process. It moves from a complaint to the to PSIA department section or to the districts to action or not. It's an investigative process, and its outcome in the event of some kind of finding of wrongdoing can be anything that's not on this list. But if it's on this list, and that reminds me of something I want to say about this list, if it's on this list, only the PFC can do it, unless the officer agrees otherwise. Now, what often happens is that minor suspensions are agreed to by the officer and don't go to the PFC. But an officer doesn't have to agree to a suspension and can take it to the PFC. Demotion and discharge cannot be agreed to by the officer. An officer can resign, but discharge by a chief must be presented to the PFC. Same with demotion. But suspension, just because I think of practical realities of managing a department, the chief can work out a suspension and merely report it to the PFC as having happened, but it doesn't have to go to the PFC unless the officer makes it go to the PFC. Now, your second question related to in this group is, how could that process be made more fair and accessible to people who are not the primary victim of the incident in question, and for people who do not have means to hire an attorney to ensure their complaint has a chance of being heard? I have several comments about that. The first comment is that the question kind of quietly placed in this question, in the question, an issue here is what lawyers refer to as standing. Who can file a statement of charges? Now, I might say that the filing of a statement of charges mechanically is simple. You just file it with the PFC, which means, as a practical matter in Madison, turn it into me. I take the mail for the PFC. The PFC doesn't have a separate book box or office or anything, so my office functions in that way. So you file a PFC complaint with me. But who has the standing to do that? The statute tells us who has standing to file a statement of charges. The statute, as many of you know, is Wisconsin Statute 62.13, parent 5. And that statute, in that statute, it says who can file a statement of charges, and it can be a chief. And by the way, the statute, nowhere in the statute that I can recall does it ever say police chief or fire chief, because it's the same rules for both departments. Chief, officer, subordinate. Those words apply equally in both departments. Well, anyway, a chief can file a statement of charges. A commissioner or the commission as a whole, and the fact that they're listed as having standing is frankly, an historical, in my view, an historical survival, an anomaly, a piece of legal archaeology. The statute goes back to the 1890s, and nowadays it wouldn't be written so that the commission itself could file charges in front of itself. That creates a terrible constitutional problem since about 1925, so that doesn't really count. And then there's a third category, aggrieved person. An aggrieved person can file a statement of charges. Now, I think you've probably concluded that I am not a young person, and I'm going to demonstrate that by my personal memory of how the word aggrieved person came to be in the statute and when. And it got stuck into the statute in the mid-1970s, replacing the term that had been in the statute from the 1890s. The term originally was elector. An elector can file a statement of charges. That's what it said for 80 years. Now, what is an elector? Well, there's some ambiguity about that. Is it a person who voted in the last election, or is it a person who's eligible to vote? I'm not sure exactly. The issue never arose in front of me, and I don't have to know what it is, because it got changed in 1975. The reason it got changed is because an elector of Madison filed a statement of charges against Ed Durkin because of events arising out of the fire department strike in 1968. And the elector didn't like the fact that a firefighter had led the union and filed the charges and so forth. And it actually is a very important and significant case in many ways. After that case was resolved and settled as a case, the police and fire labor, led by fire department labor, felt that that elector standing should be, well, I think it's fair to say modernized, because the concept of an aggrieved person is a much more common concept in administrative law. And they felt that it would be more in the interests of the department if the person filing a statement of charges would have to be aggrieved in some way, rather than simply being, in a nutshell, a taxpayer or a person in the community. Whatever the reasons were, that was changed, and that change was made in the mid-70s, and has been aggrieved person ever since. Now, so we know that in order to file a statement of charges, if you're not the police chief, you have to be an aggrieved person. What is an aggrieved person? May I have the next question, please? It's hard to say in any meaningful way what an aggrieved person is. It's something more than anybody around, an elector. It's got something in it that has to do with having suffered some kind of actual harm in some kind of way. But it's something less than, as your question phrases it, primary victim. It doesn't have to be the primary victim who was the only person aggrieved in a matter. So somewhere between the primary victim and somebody just happens to be a face in the crowd in the community is a person who, in fact, suffered some kind of harm as a result of what happened in some reasonably direct kind of way. And I can't tell you more than that. I can tell you that the Madison PFC has had to struggle with that question only a few times. And to illustrate the kind of struggle that it is, I will tell you two of the people who faced, who I don't know how much, if I'm telling too many war stories, raise your hand, but PFC had a great difficulty some years ago saying that Bill leaders had standing to complain about what had happened to somebody else in a certain situation. There was no question that the person to whom the things had happened would have had standing. But Bill Leaders, I only use his name because everybody knows Bill Leaders. Bill Leaders didn't claim to have any actual connection to those particular facts. So the PFC said, in a PFC statement of charges that Leaders filed, the PFC split the baby in a way and said, well, Leaders, you can move forward with this part of your case because you were involved in that. But you weren't involved in this, so we're not going to allow you to have standing to deal with this. And the other individual where the Madison PFC found a lack of standing was Ronnie Greer, who complained about Deborah Mesqua because of something that he read in the newspaper that had supposedly happened to somebody else in the department, that he had no involvement in whatsoever, and no knowledge of. And the PFC said, that's just too far away. You, Ronnie, were not aggrieved by that. Otherwise, in fact, I'm not saying that the Madison PFC has always granted standing in close situations other than those two. What I'm saying is the question doesn't usually come up. Because usually, and the PFC, I'm glad to say, doesn't have a lot of case business, but usually it is a primary actor who has filed the complaint. So it's not routine that we have to struggle with that question. Now, the broader question in this question is, how could this process be made more fair? And this is why I like to put this on the board. Look at what happens when the police chief or the fire chief, when the chief initiates this process and we see a PFC case brought by a chief. The chief is over here nominally, but in fact, of course, is represented by an attorney. Depending on the case, it will probably be the city attorney, that is one of the staff attorneys in the city attorney's office. Sometimes it will be outside counsel hired for the matter. So the case will be prosecuted by a competent, experienced attorney. The officer will be represented almost always by an attorney provided by the union or association. Occasionally that doesn't work out and the officer gets counsel on his or her own, but there's always an attorney over here. And I'm glad to say, the PFC has an attorney. That's me. So, and that hasn't always been true, by the way. Sometimes in the olden days, the poor commission sat up here without an attorney. And that was a defective system. But it works pretty well this way. You can see what's missing if the complainant is not a chief. Dane County is the perfect place for me to say, in that situation, there's not enough attorneys on the board. What's missing in that adversarial quasi-judicial system, with an aggrieved person as the complainant, what's missing to make it fair, or to even make it stand on its 3 feet, is legal representation for the complainant. And the way to fix that is to provide. I said I wouldn't make any policy statements. Here, I'm making one, so I'm just, write it down. I'm doing something I said I wouldn't do. But the way to fix it is to provide an attorney to this part of the triad. What people sometimes do, and I get into arguments with people about this, and I won't reiterate those arguments, I think it's a mistake to try to fix that problem by looking here. I think the way to fix that problem is by looking here. I think the way to fix that problem is to provide representation to the complainant. You know, the point of the whole line of Supreme Court cases, Gideon and so forth, is not to change the judges, it's to provide an attorney for the defendants. The defendant is entitled to an attorney. Well, the defendant in this model has an attorney. Who doesn't have an attorney is the complainant. So I think, hands down, clear, objective, logical, the solution to the problem of making the adversarial model work in a citizen complaint situation is to provide representation to the citizen. Now, there's one other little thing folded into the question that I want to comment on. It ends with the phrase, to ensure their complaint has a chance of being heard. Now, I think what that really means, in the way I believe I have construed it in practical terms, is treated fairly or receives a fair hearing. But what I can say is, generally, in Wisconsin, the law is pretty clear in Wisconsin, in my experience across the state, and certainly in Madison. If a person files a statement of charges with the PFC, they will get a hearing. That happens. The PFC does not have the discretion to not hold a hearing. The problem isn't having the hearing. The problem is what happens at the hearing if the complainant is not, if the case isn't well prepared and if it's not well presented. There's another problem that I don't want to go, I'll just allude to, which is a lot of complaints are not statements of charges. I open the mail for the PFC, there's not a lot of mail, but I open it, a lot of it is people saying, well, I don't like what so-and-so did, would you please look into this? Or they don't name the officer, or they don't give the date of the events, or maybe they refer to a different department. So just because you write it down doesn't make it a statement of charges. Remember that the officer's career and job is at stake. And a statement of charges has to pass some kind of threshold of specificity and directness. And the person filing it has to be willing to undertake the responsibility of presenting it. When I get a letter or an inquiry from somebody who actually would prefer some kind of investigative process and hasn't really yet given us a written statement of charges and kind of wants us to look into it, and I will say, well, you can file a statement of charges, and if you do, this is what you get. Is that what you want? If you want this, here's the form, fill it out, send it in, you'll get this. And you will get it. Anywhere in Wisconsin, as a practical matter, you will get it. But the fact that this is what it is often dissuades people from moving forward with it. And I don't know that that necessarily in and of itself is something to be corrected. If people could have access to advice and counsel about preparing and presenting their case, then I think I would be content to let the dust settle on, and if people don't want to bring a case, they don't have to. Look what the PFC can do. You notice something else that's not on the list? The PFC doesn't have the ability to award damages, money. It only is, generically the PFC is a personnel board. In fact, historically, generically, it's a civil service board. In fact, it's one of the early progressive era civil service reforms in Wisconsin. And it's got those kind of creaky old progressive values of civil service and the things that we associate with that and are, and that need to be done away with, apparently in certain forums. But the PFC is not judicial; it is only quasi-judicial, so that it can't award any kind of damages. So why would a person who's aggrieved bring charges in front of a PFC? And I cannot answer that question. I have no answer to that question. I'm not saying that a person should or should not. In fact, I don't think there's an abstract answer to whether a person should or should not bring a statement of charges. In light of this overall structure and this limitation on the results, it's up to the individual to decide whether or not to proceed in that model. Now, I've taken a fair amount of time on those. There are two other questions in this group, and I'll try to move more quickly with them. I wanted deliberately, I'm not just talking too long because I talk too long, although that's usually a good enough reason for me. But in addition, what I've been talking about so far is kind of the basic structure of the whole thing on the disciplinary side. So it's kind of the foundation. And I'll try to move a little bit more quickly along, and then we can go back with your follow-up questions if you want. There were two other questions were posed in this general category. Here's the first of those. Would you support there being a provision of funds by the City of Madison to people bringing complaints to the Police and Fire Commission so that all people can afford legal protection from being mistreated by city-employed police officers? And let me read you the next question, which these are closely related in my judgment. Under Wisconsin statute and case law, would it be possible for the PFC to create a mechanism for independent investigations by, one, creating a separate subordinate entity, and maintaining a bright line, in order to maintain a bright line separation between such an investigative entity and the PFC itself, such that the PFC's quasi-judicial function would not be compromised, and to avoid raising due process issues. I can tell you that the PFC would be pleased to see a panel of volunteer attorneys available to advise and assist aggrieved citizens. And that's one of these things that I can say kind of contrary to what I said and what I was going to say, because the PFC, in fact, for the past year has been trying to prod people to do that unsuccessfully. If you can find a way to come up with that, terrific. Other mechanisms are not clear to me. I'm not sure what, so the phrase in the question as it's asked is provision of funds. And aside from paying me, I'm not sure what provision of funds would do. Provision of funds doesn't answer the question. The question is, what would be the mechanism? What would happen? And then we have to pay for that. The only mechanism that I have in mind, as a practical man, is a panel of attorneys available to do this. Now, come up with a different mechanism. That's fine. But that's what is in my mind as a way to do it. If you want to pay a group of attorneys to do this, that's fine. And there would come the funds question. Or if you want to have a staff person to do that, that would be another way that funds might be used. But what I'm saying is, funding is not the first part of the question. The first part of the question is, what are we going to do? What's the mechanism? And then how do we pay for it? And I don't know how to do it other than providing attorneys at this level of this part of the adversarial model. I might note that filing a complaint, small C complaint, meaning anything you want to say, with the police department an internal complaint, is much easier than all of this. They don't require a specific form. It can be done now. It can be done online now that the city website people or tech people have tweaked things enough. It can be done online, so it's not nearly as much of a problem. But that's not the process we're talking about tonight. Now, in terms of the role of the PFC in doing this, where the second question says, could the PFC create a mechanism? I think the short technical answer to that is, I think not. I think that other principles of law come into play here. The PFC probably, in my judgment, does not have the authority to set up a mechanism like this in itself. But the Common Council, a Common Council, certainly could. And I'm speaking here generically, not just in Madison. I mean, I guess it's clear, but let me just highlight the fact that all of the stuff I'm talking about, is state statute. This is not our Madison way of doing things. This is the state statute that applies everywhere in Wisconsin except Milwaukee. Milwaukee has a separate statute that is similar, but significantly different, and we'll just forget about Milwaukee for tonight. So when I say PFC, generally, unless I clearly am talking about Madison, I mean a Wisconsin PFC. And I'm saying a Wisconsin PFC, by and large, doesn't have the authority to do this, but a Common Council, by and large, does. For that matter, anybody could. The Elks Club could do it. I mean, you could do it. I mean, I've tried to get the Bar Association to set up a panel. We kind of poked around at the law school. There's no reason in particular why the PFC should be the one providing staff and legal support to this leg of the triad. And don't be misled, the PFC doesn't have any money. So in terms of anything that a PFC might do, it would involve a budgetary decision by the Common Council anyway to provide the money for the PFC to do it. PFC isn't independently wealthy. So I think the narrow answer to this question is no, the PFC can't really do this. But the broader answer is that's not a problem. Anybody can do this. The problem isn't that the PFC can or can't do it. The problem is to define what it is that needs to be done and to get somebody else to do it who can do it. For example, the Common Council, or for example, you know, a civic organization, or the Lions Club, or whoever it might be. But I guess so. In this context, I appreciate the way this question is framed as trying to avoid the problem of due process for the PFC being involved in doing the investigation and representation. That is a theoretical issue that needs to be avoided, but I see no advantage to even stepping into that conflicted soup, because there is no advantage for the PFC to have any involvement in the, doesn't need to be the PFC's umbrella or aegis for that leg of the adversary system. We don't know. I can illustrate that one step further. I mentioned that that an officer was the subject of charges by a chief, or by a citizen for that matter, is inevitably represented by an attorney. And I mentioned that that attorney is provided by the union or association. I happen to know that. But I just happen to know that because I've been involved in this for so long. In fact, within any given case, we wouldn't know that. It's not the PFC's business where that attorney comes from. And on the occasions when what I learned later that there has been some conflict within the union about representing this or that officer, and that this time the attorney is not provided by the union. We don't find that out until 2 years later over beers. I mean, that it's just not part of the system for the PFC to know where the attorneys come from. The attorneys are there, they show up. Now that completes the first group of questions about the complaint process. To remind you, the remaining groups are the optional powers, which we can take up next, questions related to that, and then questions about commissioner appointment and PFC administration generally, which we would take up after that, assuming we go with the way we shuffle the papers. So with that in mind, what questions would you like to follow up with regard to the complaint process?
I think that the interest is that there appears to be continuous discussion in Dane County over the unusual arrest rate of minorities compared to whites and compared to demographics in the county. And of course, Chicago actually got a hold of the actual who arrested whom for what. And so I think that if, assuming that information was available, I'm not saying this is the public PFC's role, then it seems to me one could actually look at that statistic and it would be fairly obvious as to which officers are more, on a bell curve for a particular crime, arrest disproportionately numbers of minorities compared to whites. And that's what's happening in Chicago now, because they've got a hold of that information. And then it seems to me the issue is that a citizen group wants to bring a complaint against a particular officer or set of officers that are showing up as really arresting disproportionately minorities as compared to whites for particular crimes, or they're taking to the jail and booking people who are minorities, whereas they're taking whites with the same crimes and giving them a civil commitment or misdemeanor for the same misdemeanors, which are not then handled by the Attorney General's office and get into CCAP, et cetera, and result in actual formal incarceration, probation, parole. So I would assume that the public could have standing in such a situation because they would have names of particular officers and pursue such a complaint, because it seems to me it's the only way we're ever going to get at this issue. It's actually, nobody gets in the jail, nobody gets in prison unless a law enforcement officer initiates an arrest and charge. And then, of course, the DA has to either confirm that or not, but that's where it all starts. Is there any issue over standing if the community group actually had that information and would bring a complaint to the PFC against a set of officers that they felt disproportionately arrested minorities compared to whites for similar crimes?
Well, I can't realistically answer that question. I can say that drafting that statement of charges would take a skilled, careful legal hand. And then the PFC would just have to grapple with the document in front of it.
But there shouldn't be a standing.
Standing, I mean,
In terms of citizen group saying this.
You don't take an answer when I say I'm not going to give an answer. I'm not going to answer that question. I might very well be a standing problem.
Okay, that's fine.
Whether or not standing or anything else, whether all the elements of a statement of charges along those lines would have to be very carefully prepared.
Sure.
and standing is one of the things that would have to be addressed. It's not clear to me, for example, that a group can be an aggrieved person. I wish, well, I don't actually, honestly, among friends, I don't wish that I was younger. But I don't think that I'm young enough to anticipate that I will see that issue fully litigated. But I don't, would the aggrieved person have to be a corporation in order to be a person? A corporation is a person. Can a corporation be an aggrieved person? I don't know the answer to that. I'm pretty sure, because the area of law that we're talking about is fairly narrow, and I'm reasonably well acquainted with it. I'm pretty sure that there's no Wisconsin case law on the question of whether a statement of charges can be brought by a corporation. I think that that would raise the question of whether a corporation can be an aggrieved person. And if the party was not a corporation, it very likely could not have standing as a person, because if it's not incorporated, it may not be a person. Now, that's a trivial side issue to what you're raising, but it illustrates the problems of putting together a document that will survive as a statement of charges. And keep in mind that what's necessary here over the arc of a case is not surviving scrutiny by a PFC. That is the very beginning of the matter. You have to get in front of the PFC, but the PFC decision is subject to judicial review, and I can assure you will be judicially reviewed, whatever decision the PFC makes. If a PFC makes a decision that's hostile to an officer, it'll be reviewed in the course of an appeal process by the officer. If a PFC makes a decision in an important matter that's hostile to a chief or a complainant, it'll be reviewed in that context. And the question of standing, along with every other legal question that the PFC deals with, will be scrutinized with great care on judicial review. And for reasons that are far more involved in the inner intricacies of PFC law than you care about at all, or I hope you don't care about such details, I can tell you that I often think and tell people that one of our major jobs as a PFC in a disciplinary matter is simply to compile the record for the judge to look at. We make a decision, but the judge looks at the record in a uniquely comprehensive way, making a decision from scratch. The legal Latin for from scratch is de novo, anew. The court looks at a PFC disciplinary decision de novo, but based on the record from the PFC. It doesn't hold a new trial. It uses the record of the PFC matter. That's why, if I may say so, I'm so damn particular about what we do in the PFC. Because we don't want it to come back to the PFC from a judge saying, well, this record is incomplete, or you made this mistake or that mistake. We want the record to be all there. So all of this detail about statement of charges, standing, so forth, you can think of it as the rules and requirements of the PFC. But this is the foretaste or the theater lobby where the performance, in a sense, is in front of the judge. And the record has to have all of these things covered, or the case won't stand. So I don't know, standing and everything else will be an issue in the kind of case that you present. But keep in mind what I think is one of the main things that I've said. You will get a hearing. A statement of charges gets a hearing. But you do have to have a statement of charges.
I don't think the statement of charges is a problem. I think that the problem is, I mean, I've been sued.
I'm sorry,
Yeah,
we're gonna
okay,
move
that's
to it.
fine.
And we'd
That's
love to break that down with the
Okay.
CRT. So if you want to come to a meeting,
Sure.
because I'm hearing all kinds of creative ways in my mind to approach what you're talking about, and I think that would be great.
Okay.
So we've got, we're gonna stop
Well, there isn't, I didn't see the clock over there.
A
That's-
couple more questions, so,
Does the court that's hearing this de novo have more options than suspend, demote, and discharge?
No. No, it doesn't. Well, depending on, in the exact procedural context, it doesn't have any other disciplinary options. It may, in certain kind of ways that I won't go into, it may have the choice of sending the case back to the PFC rather than simply reversing the PFC. But that doesn't happen very often, and it can't do anything different. It just acts like the PFC with the same things that the PFC can do.
I have 3 really quick questions. One is there a cost to someone bringing a complaint other than the hiring an attorney? Is there a statute?
Write that down. Other than hiring an attorney. No, there is not.
Is there a statute of limitations for when something?
What an excellent question. In my opinion, that I'm just thrilled, or at least delighted, that you asked that question. I think that is one of the key practical questions of the night. No. There is no statute of limitations. Now, why is that so key? I'll tell you why it is in practice. Because there is a practical administrative statute of limitations on this process. Every department in the state, by law, has to have a complaint process, an internal complaint process of some kind. And they all have pretty much the same. And they all have some kind of statute of limitations. It varies, it's got technical ins and outs, it will be suspended, tolled, as it's called, if there's a criminal case going on, so they won't look into a disciplinary complaint while the person who's made the complaint is in trial. They don't want to interfere with the criminal system, so they will suspend it. But by and large, there is a statute of limitations for the internal complaint process, and it's by and large short, 60 days, 90 days, something like that. I don't know what it is exactly, and it varies, and it's subject to modification. There is no statute of limitations here. So what I always tell people is, you're thinking about what to do, you're not sure what to do, you're not sure you want to do this first. See what happens. Then come to here if you want to. You may actually learn something from this. They will, depending on the matter, there will be some kind of investigation. Maybe you won't be satisfied with it. Many people are not satisfied with police and internal investigations, and some people are. Whether or not you're satisfied, you may learn something from it. It's a form of discovery. Do this first within this statute of limitations, because there is no statute of limitations here. So you can come back here later. Now, in any legal situation where there is no statute of limitations, that doesn't mean that you can come back whenever you damn please. There's still a kind of vague common law theory called laches, delay. And if you wait 17 years to complain about the way an officer wrote a parking ticket, that's going to be too long. But it's a softer, squishier, fact-specific kind of thing. It's not 90 days or else. It's not 2 years or else. There is no statute of limitations on this process. You know, I have no idea why that is so. I think it's extremely interesting, and it's fascinated me for years, and I think it's of great practical significance. Third question?
Where's the burden of proof?
Here. And it's the lowest burden, preponderance of the evidence. In other words, 51%.
oh, sorry. Guys, do get out.
I was going to ask about the constitutional problem. What are you going to ask about? Sometimes. Can you allow both of us?
Yeah, I guess anything we should tell everybody.
A quick question and then a potential follow-up. A quick question and then a potential follow-up. Does the PFC have subpoena power?
Yes.
And
Scott, that's the PSC can issue subpoenas.
And the follow-up is, say that, okay,
Of course, for that matter, so can the attorneys. It's kind of, if there is a proceeding, then an attorney can issue subpoenas. If there's sometimes, but I've never, ever, in the entire state of Wisconsin, and I do this kind of thing around the state as well as America, never had any trouble with attorneys issuing subpoenas. In principle, if an attorney wants, if a party wants the PFC to issue the subpoena, it can and will. But when there are attorneys, typically they issue the subpoenas.
and like, so if the say that Common Council allocated funds for investigative staff, how would a subpoena occur through that?
Well, that could be a glitch.
That's part of why I framed the question
Yeah.
in the way I did.
That's, I think, answering this pretty abstractly, but I think that the subpoena power of the PFC depends upon the prior filing of the statement of charges. So I think you have to have a statement of charges filed in order for the PFC to be able to issue subpoenas.
Yeah. I want to go back to what you said before about I guess the problem that you identified in the statute. You know, the statute talks about that a member of the PFC or the PFC itself as a body can bring charges against an officer. And you noted something about the constitutional problem, something about 1925. If a community group was let's say a community group, maybe it's those folks who are here at the Bureau, who managed to convince a PFC member or the entire board to bring charges and kind of force that issue, what would happen?
Well, I'm not entirely sure what you even mean. Look at my board. A PFC has 5 commissioners. If the PFC as a whole or Commissioner 1 moves over to the complainant table, who's the judge? Theoretically, who is the tribunal? If a commissioner is over here. As a practical matter, who is actually going to ask the questions? Who's going to do the investigation? Who's going to write up the statement of charges? Who is going to be the attorney? As a legal matter, how is this tribunal going to provide due process to both of these parties? This would not be any more fair than if Commissioner 5 went over and sat at that table. The whole point of the system, the process, is to have a neutral, independent, third-party tribunal. That's the point of the model. Now, the world at large does not necessarily run this way. This is, in fact, a little kind of mini representation of the British common law system. It's not the only way things work. All over Europe, they do things differently. not to mention China. But without raising questions about fundamental fairness and international comparative law, a Napoleonic code system or a German code system doesn't operate this way. But the British common law system operates this way, with a dependence upon adversaries presenting a case to an independent tribunal. Now, the question as it was framed for me does get at this problem, and I'll tell you how it arises most in practice. The way that it arises the most in practice is with respect to a chief. Because as a practical matter, day in and day out, the complainants that we see are chiefs or aggrieved persons. We'll decide this question that you're pushing, this problem that you're pushing about the adequacy of the system for aggrieved persons. In fact, and that, I don't mean to raise or argue that issue, the fact is that year in and year out, there's a significant number of cases brought around the state by aggrieved persons in Madison and elsewhere. So, in fact, that happens. When the chief or an aggrieved person comes in front of a PFC, aside from the attorney question, at least the adversarial system process isn't problematic. You have party over here, party over there. But what happens, this is a problem for PFCs. I get asked this question all the time by PFCs around the state. What does a PFC do if it has concerns about a chief and there's nobody filing a complaint about the chief? Now, if somebody files a complaint about the chief, that's okay, because then the system, this process works fine, because the chief is subject to the same rules. So an aggrieved, a person who is aggrieved by the misconduct of a chief can file a statement of charges, and the chief would then be over here. But the problem arises, as you can well imagine, particularly in small towns, that there's some people who are unhappy with the chief, but they don't want to file the statement of charges. They're a little uneasy about being on the wrong side of the chief, but they're not happy about the chief. What's the PFC supposed to do? Well, the PFC is supposed to solve the problem. They're supposed to do something about it. There is no easy solution, but there is a structural approach to it that works in that situation, and that's hinted at in your question. For lack of anything better, the best thing is to have an aggrieved person come forward and file the charges against the chief. That's how Chief, who's the guy that ran the squad car into the tree in the 50s? I can't remember his name. The notorious chief.
Irene Harrington's dad was on the police and fire commission.
I've forgotten the name of that chief. But in any case,
That was half the story.
it was the chief before Emory, before Wilbur Emory was the chief. Before my time, I wasn't in Madison at the time. That chief was brought up on charges that were brought on by an elector, as the statute was in those days. And if I remember correctly, it was basically FU, the publisher, who was behind that. I don't remember who the party, he might have been the complainant, I don't know. But what I'm saying is, structurally, that's the way to do it, to have an aggrieved person file the charges. And somebody with resources and independence and whatever to be willing to do it. What a PFC can do is, if a PFC has reason to think that there might be a basis for charges against a chief, then a PFC can engage special counsel to investigate that matter, that problem, on behalf of the PFC. Authorize special counsel to bring charges in the judgment of special counsel, if there's a basis for them, in the name of the PFC. But Meanwhile, the PFC and the commissioners stay completely out of that process. So in effect, they establish an ad hoc, independent special prosecutor. If I'm talking to lawyers, I refer to that as a special prosecutor because lawyers know that a prosecutor doesn't have to prosecute. Hiring a special prosecutor doesn't mean that the person is going to be prosecuted. It means that the prosecutor is going to look into it and decide whether or not to prosecute. When I'm talking to lay people, I usually say special counsel because that makes clear that the person may or may not prosecute the charges. So there is that mechanism by which a PFC can get at the problem of what to do about bringing charges to the chief, against the chief, if nobody will do it and the PFC thinks that maybe there should be. But the PFC can't get very far into that issue in a specific case because it jeopardizes its independence and needs to be sure that when those charges come down, if they do, as PFC versus Chief Smith, that's a pure formality. And you can be sure, of course, that the chief defending against those charges is going to probe every possible challenge on that basis of the unfairness of the commission or the lack of independence. I've been involved in 2 matters where that structure has been used, and 2 other communities around the state. On my recommendation, PFCs did that. In one case, the special counsel came back with a report that fully exonerated the chief, and as soon as he filed the report, the chief retired. So I'll let you figure out what happened in that. And in the other case, or instance, while the special prosecutor or special counsel was working on the matter and they're just about ready to file charges, the chief died. So neither of those cases gives us very much instruction.
Who would the special counsel be?
Well, another attorney, of course.
Well, would the PFC choose?
Yes.
Could they pick any attorney too?
Yes.
Thank you, sorry.
So, can we move on to section 2? Are we ready for section 2? Okay, we're in fast forward mode. We got a month for that?
Half an hour left.
Yeah, we've got a half hour left. Why don't we say that we'll keep the clarifying question time for this section to 5 minutes max, and then any other questions, we should be willing, if we were to forward you any other clarifying questions on, in your free time.
I would take a crack at that.
Okay.
I may have less to say about optional powers than you would like. Maybe I can, I don't know, it's silly for lawyers to say that they won't take long or they'll be concise or whatever. It's like saying, you hear that all the time, and it's like saying, well, we're not giving you legal advice. I mean, they just say that. One thing I will do in fast forward mode, I won't read the questions.
Are you aware of which cities,
Yeah.
I'll remember because these are different from what.
Oh, okay.
But is it, are you aware of
Yeah,
which
that's what,
cities?
right.
Okay.
Well, yes and no. The League of Wisconsin Municipalities website lists them. You can, with a couple of clicks, you can find those cities. There's about half a dozen, give or take. I don't know exactly what they are. As a matter of fact, I have worked a couple of times with municipalities that have optional powers, but never in any matter that had to do with their optional powers. Only in fact, one of the 2 instances that I just described about the chief problem, coincidentally, was an optional power city, but that our problem had nothing to do with the optional powers. So I haven't ever worked on an optional powers related problem with anybody. You can get the sites from the League of Wisconsin Municipalities. My understanding, and what I've heard the same thing from the attorney for the league when we've shared a place on a panel talking about PFC things. My general understanding is that the optional powers are an historical phenomenon, and there's maybe even a little bit of a geographical thread to them. They tend to be over in eastern, central and northeastern Wisconsin. They've been there forever, the ones that have it. I'm not aware of any effort anywhere to move two optional powers. That's not to say by any means that it hasn't happened, but I don't know of it, and I've never heard my colleague with the league talk about that or refer to it. I think it's just something that's left over from very early days of the PFC statute generally. What do they do? What do they use their powers for? Well, they just run, the city runs using the optional powers. The optional powers kind of divvy up. The way I look at it is the optional powers provision of the statute, which, just to refresh here, that it's these little extra powers that can be given to a PFC by referendum and can be taken away from a PFC by referendum in a municipality. And they have to do with management of the departments, and they basically shift, as I read it and understand it, they shift some of the management authority, but not all, from the common council or whatever the city has, like a common council, to the PFC. I don't think that the optional powers statute, as I read it and as I believe it would be interpreted, I don't think it creates any powers that don't exist in a standard non-optional powers community. I think it shifts some powers from the council to the PFC, basically non-budgetary matters, but it leaves a lot of budget matters and a lot of decisions about real estate, for example. A PFC can't decide where to put a firehouse or whether or not to build a firehouse. An optional powers PFC has to still depend on the common council for that kind of thing. The only referendum that I have any knowledge about personally, or have ever heard about, was a referendum in Shawano about 1985, give or take, which revoked the optional powers. Shawano had optional powers and went through a period in the early 80s of great upheaval and conflict and controversy around a particular chief. I had some involvement in that part of their problem. And then apparently in some wake of that business, by referendum, reverted to a non-optional powers PFC. That's the only referendum that I have any knowledge of in my time at this. And I don't think that the statute gives us any more guidance about how a optional powers PFC would relate to a chief than it does about how a common council relates to a chief. Now, I reiterate that I may be reflecting some ignorance on this point because I haven't dealt with this legally. I've dealt only with the disciplinary parts of things in the context that we're talking about. And of course, some other personnel matter issues about hiring and so forth. But optional powers, I haven't dealt with this directly myself, and therefore I'm not as conversant with the case law about this, if there is any. But my view of it, my expectation, my reading of it, for what it's worth, is that the relationship issue is the same, whether it's the optional powers PFC or a common council, with the exception that in an optional powers community, it would actually be more complex because it retains some, because the common council retains some of the powers of, for example, in my hypothetical, I'll speak quasi-hypothetically here, be a common council decision to locate a firehouse or a police station. even in an optional powers community. So a police chief or a fire chief who was planning for the location of those facilities would still have to deal with the Common Council, but would also have to deal with the optional powers PFC in more general ways about planning staffing levels and that kind of thing. So that's how I perceive, for what it's worth, that's how I perceive the question of the relationship of an optional powers PFC to a chief. The final formal question here in this category is kind of encompassed in what we've been saying. How could a referendum expand the current powers of the PFC? Well, by providing the optional powers. I mean, read the statute. With a referendum, a successful referendum, would put the PFC in the position to have those powers. And without the referendum, it doesn't have those powers. Now that maybe was a fast track, although you made it, there's a serious, and I remember this now from other events, there's a serious logistical problem with this library space. I love the new library. I love this space. We've used it in the PFC and for other things. But you can be in this room in such a way that the speaker can't see the clock.
Oh, right, so it's 8:25.
Okay, so you just said, what do you want follow-up questions on this?
Well, we've got, did that answer all four? I've got four here.
I pretend that I answered all four other questions, although.
What'd you say?
I think it might be some important follow-up questions.
Okay, great, yeah, for sure. Follow-up questions?
So, under the optional powers, you have the power to set rules and regulations for patrol management. Does the Common Council actually have such power? If the Common Council wants to change NPD policy, does it have that power?
Well, that's a good question. That's a good question. From what I just said, it would be fair to infer that I think the answer probably is, I think so. Now, it's a complicated, I won't say problem, or it's a complicated problem, not just a question. I mean, you asked the question in a straightforward way, and I think the answer may be yes. But it is pretty complicated. For one thing, at least traditionally, another area that I can't claim to know about anymore, but there used to be significant labor law questions involved in rules and regulations. And I don't know the status of that dimension of Wisconsin law with respect to police and fire departments. I just don't know. And there are wide-ranging questions and practices regarding department management styles, both police and fire departments, as implicating what used to be called quality improvement, and that whole dimension of things. The fact is that in both departments, the existing rules and the structure of the rules have not been imposed by a hierarchical authority, either a chief or a mayor or a common council, but have evolved through a process of department of change and input and so forth. So it's not a simple matter for anybody to just say, well, now they're going to, this is what we used to say they are, now we're going to say this is what they are. That's, in practice, not a simple question of who has the authority to do it. But because I read the optional powers referendum statute the way I do, and I admit I tend to think that those powers that are specified as the optional powers reside in the council in the absence of the optional powers. And I say that, one last fudge factor, I've never looked up any law on that whatsoever, other than reading the statute. Never had any reason or need to until this meeting.
Thank you.
Other follow-up questions on this section?
Where would we find record of PFC decisions, where do we find record of those for the state? Or is it listed for each municipality in a different place?
You mean actual disciplinary decisions?
Mm-hmm. Yeah, if we wanted to just sort of look back at and research.
Well, they're not, the more general you make that question, the easier it is to answer. They are not reported cases, as a lawyer uses that phrase. In other words, they're not published. There isn't a systematic way that you can find them. In Madison, we're not really close to having a systematic way, but if you asked me, I could provide you with recent, with decisions going back a couple of decades. I have no idea how to find out disciplinary decisions in Oshkosh, for example, or just to take a place at random. If it goes to court, you find it out through the court system. But if it doesn't make it into court, then, I don't know, how do you find out zoning board of appeals decisions from La Crosse for the last 20 years? I mean, I don't know. In some communities, the clerk might have those, but in many places that they wouldn't. They don't. The decision is not filed with the clerk necessarily. It's filed with the secretary of the commission, which just means it's in somebody's box somewhere.
So it's somewhere, it's just not assembled and like in a...
Well, it's somewhere if somebody hasn't thrown it away.
Oh, interesting.
I can tell you, I don't throw things away.
How long have
People
you
close to me will tell you that also.
How long have you been counsel to the PFC?
Since 1981.
But these records would be subject to state record retention rules.
Yes, in principle they are, yes. Now, of course, the fact that they're subject to state records retention doesn't mean that they are retained. I mean, one of the functions of state records retention law is to throw away records.
Right.
So,
Just says when it's okay.
yes.
Doesn't the executive, the mayor, contain certain authority? Isn't just common council?
Yeah, sure.
The mayor, normally, in my experience, appoints the police chief, but maybe that's just politically.
No, the mayor never appoints the police chief in Wisconsin. Never, ever, does not. The PFC appoints the chiefs. That's one of the core basic concepts of the PFC since 1890, to remove the chiefs and the subordinates, as to say, the sworn officers, not the civilian employees, but the chiefs and the subordinate officers are a civil service system, not a political appointment system. And, in the olden days, you got a new police chief every time there was a new mayor. And in Milwaukee, you would get new lieutenants and sergeants every time there was a new mayor. And people got tired of that. And so so the PFC appoints the chiefs, and we haven't been talking about that yet tonight. But a mayor does not make that appointment. But you betcha there's tension between mayors and chiefs. And there's all kinds of theoretical ways for that to appear, because the mayor, some general language in the statutes it says that the mayor is the head of each, of all departments. Some mayors sometimes feel that that makes them head of the police department and fire department, depends who they're fighting with at the time. And various chiefs exercise various degrees of independence in response to that. So that's a continuing dynamic, definitely, between the mayor, between a mayor and a chief. A common method that's used, Chief Baumann would not allow Mayor Baumann would not allow Chief Amescua to have a raise for many years. He was very frustrated and limited in what she could do to supervise the fire chief, but she could arrange not to provide a pay raise. So Chief Amescua didn't have a raise for quite a while. Well, other department heads would get kind of a standard laddering system. So there can be all kinds of tensions. And there were periods in the early days when Mayor Southlin had serious conflicts with Chief Cooper over who was in charge of the police department. So, yeah. Other follow-up questions, particularly on the optional powers business? Yes. Okay.
Has there ever been a case where the Common Council as a unit or anybody on the Common Council operating on behalf of the Common Council or the mayor has been a complainant?
I didn't put the hook on the question.
Has there ever been a situation in Wisconsin where where a Common Council member or acting as a member of the Common Council or as a representative of members of the Common Council, or has there ever been a case where a mayor has been a complainant against a chief?
Yes, that has happened. In principle, under current law, under the aggrieved person, I blithely say current law, meaning the law since the previous century. That would be quite possible. It's just that they would have to be an aggrieved person. I think it's it's a question that has intrigued me at the level of not really caring, as to whether a mayor might claim to be aggrieved by somebody's actions, presumably a chief's actions, that aggrieved in his mayoral operations in a way that nobody else would be aggrieved, but because he's the mayor, that makes him aggrieved. That opens him up to being aggrieved in different kinds of ways, and it may. So it is important that a mayor as such, or a city manager as such, the chief executive, does not have standing per se. But if such a person, or a common council member, is an aggrieved person, then they could have standing. That might raise other questions, particularly with regard to subordinates, where the standing issue would be the same, although I think there'd be less likelihood of a charges being brought against a subordinate. But one of the legally significant features of this system is that the PFC is not the employer. The employer is the city, and the PFC is insufficiently separate and independent as not to be considered the employer for due process purposes. There's a line of cases going in two different directions, well, making a distinction between two different situations, the county and the city. In the county personnel board can function in a similar way, but it is a creature of the county board. It is not an independent body. And the Wisconsin Supreme Court has said that because of that, sheriff's discipline, that is deputies' discipline, not the sheriff, not the elected sheriff, but the subordinates in the sheriff's office who are disciplined through a somewhat similar, or might be disciplined through a somewhat similar system. they have a different set of review and arbitration rights, because this is not really an independent system for them. It's the employer who is sitting at the table. Where the PFC is not the employer and is independent, and so therefore the statutory system for police and fire provides sufficient independence that it is not well, the cases involved arbitration. What could be arbitrated and what could not be? And the sheriffs can, under the previous law, as I say, I'm not keeping current with what goes on across the street in this regard, but under the law at that time, sheriff's discipline was subject to negotiation and arbitration. Police discipline under 6213 is not statutory. This part of it, because the PFC is independent. There's another Latin term, extremely important. We've got to keep all our Latin terms together here. Sui juris, its own law, its own entity. The PFC is not the city. The PFC can sue and be sued. It is independent. Well, anyway, so I don't need to carry, I'm off I'm back on 33 1/3. I should get back up to 45 here on covering what you're asking. So is there more follow-up?
If the common council were to change a police department regulation, as you said, maybe you think that they probably could, they would probably do so by resolution, by passing a resolution, and voting on it, right? If the PFC had optional powers and were setting rules and regulations, as the statute says that they can, what would be the internal process on the PFC for doing that? Would it be a vote amongst the 5 members, or what?
Well, ultimately, it would be, if it was a PFC decision, it would ultimately be subject to a vote. But the mechanism of getting it to a vote, I can't foresee what that might be.
And PFC decisions are made by a majority
Yes.
vote?
Yeah, a majority of a quorum.
Should we go to the next section?
As a practical matter, like most bodies, fortunately, and decisions are made effectively by consensus or by unanimous decision. Occasionally, that doesn't mean there isn't a vote, it just means that a matter is likely not to come to a decision until a consensus has been reached about it. So the Madison PFC, generally speaking, acts on what looks like a consensus. From time to time, that's not true. And it's certainly in disciplinary matters, many cases are decided on a non-unanimous vote, 3-2 or 3-1 or whatever. It depends how many people there are. A disciplinary decision, and any decision, can be made by 3 commissioners, a quorum. In fact, in that sense, 2 commissioners can make a decision if there's a quorum of 3, and then 2 people can make that decision. But the fact that that's legal doesn't make it a good idea. And that rarely happens. But it does often happen that maybe not all 5 people are present at any given time.
I think I know that. Are you required to reveal conflicts of interest, Scott?
Well,
Yes and no. I am, but as an attorney, my client is the PFC, and I can't represent the PFC in a situation where that is a conflict for me, or what actually is more likely, I won't represent somebody else where that causes a conflict with my representation of the PFC. So standard attorney rules apply to me as an attorney. With respect to the commissioners, the ordinance, I'm not super acquainted with this because the ordinance aims at financial matters and requires disclosure statements and so forth for public people who are involved in executing contracts and making financial decisions, the kind of thing where there might be a conflict of interest. Commissioners don't have any responsibility without the optional powers, maybe even with, don't have that kind of responsibility. And so as a general rule, to the best of my recollection, Madison commissioners have not had to file the ordinance disclosure of financial interest because they're not involved in any financial business in the course of their duties. On the other hand, they would still be, in my judgment, they would still be subject to kind of background rules about acting where they did have a conflict of interest. For example, it would probably be improper for a commissioner to vote on the appointment of his sister as the chief of police, to make something up. But the commissioner wouldn't have to disclose ahead of time that he had a sister who might want to apply to be the chief of police. But if a decision comes along in which there might be a conflict of interest, a commissioner ought to refrain from participating in that. Maybe it's a matter of people's ages who are on the commission, or likely to be on the commission. I don't recall there ever being a commissioner who had a relative.
Attention please, the library is closing in 15 minutes. If you plan to check out materials but do not have a library card, go to the checkout desk at either first or ground floor now.
I don't recall a situation in which a commissioner has had a relative involved in a hiring or promotional situation, or for that matter, a disciplinary one. So I don't recall that issue ever arising specifically in terms of the Madison PSC. Do you want me to look at other parts of this section?
Well, they want us out by, like, we get the ones. Okay. Can I start packing up quietly while we answer the other questions?
Sure.
Okay. I actually am particularly interested in number 10, or well, to what extent does the PFC exercise detailed oversight over hiring?
Oh, well, thank you, Amelia. That's the other question where I want to use the board. He's never erased as persuasively as a good old-fashioned chalkboard. This is a diagram that commissioners and especially fire department staff and some police staff have seen me draw many times over the years. I hope I can remember it. This is the hiring process. Recognize it? This is the formation of a city. Set up a police department, have a common council, get a budget, raise some money. We got a police department of a certain size. I won't go into all of this. You have a PFC. The city says we need 5 or 20 or whatever officers. Hire them. The PFC is responsible for that hiring process from that moment. It doesn't make the decision, we need 5 officers or 10 officers. It doesn't decide what the authorized strength of the department will be. But the city, in its mysterious ways, says we need 10 more police officers. The PFC starts a process of recruiting, testing. The statutory word is examination, which is a very old term, reflecting that civil service history that I was talking about. But it means all the things that happen: physical agility test, written examination, oral interviews, all of that kind of thing, leading to an eligibility list. This is a list of people who the PFC says can do the job. The list goes to the chief. The chief does his various things, interviews, further testing, whatever, and comes up with a list. Call this the hiring list. This comes back to the PFC,
Attention,
which
please.
says,
The library is closed to
okay,
If you wish to check out library materials, go to a checkout desk.
and
on
at
the
that
side.
point,
All library materials must be checked out before 9 o'clock.
at that point, the person is hired. The practice in Madison for either department, I'll just make up some numbers to illustrate it, would be that the eligibility list would have, well, let's say that the chief is going to hire 20 people, because the city says we want 20 people. The eligibility list will have 60 people. The applications, there will be 1,500. Now, this is the broadest sketch of the system. Its characteristics are that it goes back and forth between parties. The city makes some decisions, it goes to the PFC, which makes some decisions, goes to the chief, who makes decisions, recommendations subject to the PFC action. Only at that point does the person actually get hired. And by the way, there's also a mechanism I won't go into for that hiring being probationary. That's a complication we don't care about. Everything here belongs to the chief. Everything here belongs to the PFC. But for many years, anywhere in modern life, the PFC does not personally do all this. How could they? Now, actually, 100 years ago they did. There was a time when PFC went down to the armory on campus and gave the test for firefighters. I've heard that story from people that are still alive. They gave it. But no, that doesn't happen. The PFC delegates a lot, and I'm leaving out a lot of detail here. Physical agility test, what have you, and a lot of detail here. Multiple interviews, psychiatric interviews, all kinds of things are going on here. The PFC delegates this part of it. Where? To the department. Not to the chief specifically. And in fact, in both departments, Madison is big enough, this is to some extent a matter of being big enough that this is practical. You can't do this in Hazel Green. But in Madison, it's big enough that the chief actually stays out of the detail of this process. This is a staff process. It is department staff, but we always tell them, and they report this to the PFC. They're working for the PFC, even though they're in fact, working for the department. So the PFC develops the eligibility list, turns it over to the chief of police. So that's that model. I presented it somewhat in abstraction. I think that the keys to it are that this component of it is the responsibility of the PFC, and that inevitably, it is substantially delegated to department personnel. How else is it going to be done? I'll tell you how else it can be done. It can be done like they do it in other places, like Milwaukee or Chicago or New York, where you have an academy that does all that. Madison is not quite big enough to have, to fully, for the PFC to fully staff this function. So in Madison, this function is still combined between the department, but delegated to the PFC. It's further complicated because little parts of it may also be subcontracted, particularly the fire department gets subcontracting help from some outside consultants on their physical agility test. Okay,
Thank you.
Follow up on that one?
Yes, yeah, well, I don't know that we have, yeah. They're gonna do
Yeah.
us.
We have- Thank you.